you and I have very specific roles. I'm the judge of the law, which means I have to preside over the trial, have to make rulings on matters of law, and I have to give you the law at the conclusion of the trial, which you will take and apply fairly and impartially to the facts that you will determine at the end of this trial. And you alone now are the sole judges of the facts of this dispute. And as we discussed when I qualified you, you'll make that determination when you're instructed to begin your deliberations and evaluate the evidence in this case. And the evidence consists of nothing but testimony of witnesses and exhibits that are introduced. Now, you're going to hear remarks from me. You're going to hear remarks from the attorneys. I'll remind you throughout the trial, my remarks, the attorney's remarks are not evidence. They're important parts of this trial, but they never should be considered evidence because the testimony of the witnesses and the exhibits introduced through their testimony are what you ultimately will evaluate and make your ultimate determination. And I also mentioned to you yesterday, without knowing you previously, that each one of you is eminently qualified to perform the task that you just accepted. And you brought with you everything you're going to need. And that may sound silly, but it's true. We, every day of our lives, as I discussed, assess what somebody says or what we read, and we decide for ourselves whether we believe it or not. And those tools that we use to assist us, you will use when instructed to begin your deliberations. And frankly, it's nothing foreign to you, it's nothing new. We do it, we've done it all of our lives, and you've done it all of your life. You also brought, while those tools are important, you brought something else which I would add is really equally important. In not so many words, you saw me excuse some people because they said, I can't be fair. I can't fairly and impartially. And some of you responded and said, yes, I can set that aside and I can make my decision based on the evidence and it'll be fair to both sides. And that's just what that oath just said, based on the evidence and the law. But those that said I couldn't, we excuse. Why was that? Because they didn't have an open mind, as you did. As each one of you, without saying it specifically, you said, I have an open mind. I haven't heard or seen or read anything that causes me to predetermine anything. That's important. It's important to this entire process. It's probably the most important part for you. Because as human beings, I don't know about you, I have a tendency sometimes, and the lawyers with whom I've had the privilege of working over the years would probably endorse this, of maybe being it's a fault, being a bottom line person. Get me to the point. I know where you're going. Well, sometimes I'm right, but sometimes I'm wrong. I happen to live with somebody who's not that, and it drives me somewhat, have some issues with it. She's not that way. She wants to hear it all and then think about it and then give a response. I tell her, you're getting a lot of praise that you really ought to pay me for, but not seriously. But that's precisely what each one of you should be in this process. Do not, if you happen to have a tendency that I do, resist it. Tell yourself, don't do that. I can't, because if you do, you violate your oath. It's important to the entire process that you keep that open mind throughout it. And then can only change that when I give you an instruction to begin your deliberations. And folks, that's the last thing you'll hear from me before you leave this courtroom, is when you may begin your deliberations. So until that instruction is given, you're under your oath. You have to keep that open mind. It's also important in this process because there are 4 distinct parts of this process. And I don't know whether you've been involved in any cases as a juror in a civil trial or been involved in your life in a civil trial. The 4 parts are the same. There are differences in a criminal prosecution versus a civil. We'll talk about those in just a minute. But The four parts are, in just a moment, you're going to hear from the attorneys in what we call opening statements. You hear from them twice, once before you hear the evidence and once after you hear the evidence. Now, their remarks as officers of this court are very important, and I know you'll give them your undivided attention. The opening statement will give you an overview of the dispute. They may discuss some of the factual issues. They may discuss some of the law that you may hear. And it gives you basically a roadmap of where this case will be going and how it will be proceeding. So it will be helpful in that respect. Following the opening statement, they speak to you the next time after you hear the evidence, which will be the second portion. Unlike the opening statement, you will have heard all the evidence, and at that point, they will discuss that evidence with you and suggest reasonable inferences that you may draw from that evidence, and I know you'll find those remarks helpful when you are instructed to begin your deliberations. But in between, you have the evidentiary portion. Now, one of the major differences in a criminal prosecution versus a civil case, a criminal trial versus a civil trial, is a burden of proof. There are situations in civil proceedings where a defendant has a burden of proof. Not generally, but there are some. Not so in a criminal prosecution. The only party that has any burden of proof in a criminal prosecution in this state and every state in the United States is a person who makes a charge, the state of South Carolina. And they have to prove each element of each of the crimes that they've alleged. And they have to prove it to a standard, which is another distinction between a civil trial and a criminal trial. In a civil trial, typically the burden of proof is preponderance or greater weight of the evidence. Simply stated, as it more probable than not, more likely so than not. In a criminal case, the burden of proof, and I'll define it for you in greater detail when I give you the charge, which will be the last phase of this process, is beyond a reasonable doubt. And I would tell you that a reasonable doubt is that doubt that would make an honest, sincere, conscientious juror who's searching and analyzing what they find to be credible and believable to hesitate to act or take some action. And it's that standard that you'll be instructed to apply to each of the elements, which I'll give for you, the element of conspiracy to commit or to kidnap and kidnapping, and I'll give you the elements of each one. And you will go back and analyze the evidence and decide, did the state prove that, to my satisfaction, beyond a reasonable doubt? If on each of those elements your answer is yes, then as to you, that state has met its burden of proof. If anyone says, well, no, I'm not satisfied with that, it might be, it could be, it's possible, but that's not beyond a reasonable doubt, then the state would have failed to meet its burden of proof on that. If collectively you agree that the state has failed on one or more elements, you must return a verdict of not guilty. That's what a verdict means in a criminal state, in a criminal prosecution. Guilty, the state met its burden of proof. Not guilty, the state failed to meet its burden of proof and convince you to the requisite standard. On the other hand, if the answer is to each one, yes, I'm convinced, then you must return a verdict of guilty as to that charge because why? Because the state honored the law and met its burden of proof and is entitled to a verdict of guilty because they proved every element beyond a reasonable doubt. And that's what this case will be about. You'll be looking at it, and the only party that has any responsibility to present any evidence for your consideration is the state. A person such as Mr. Moore has no burden to prove one thing at all. They don't have to prove their innocence. They don't have to explain anything. They don't have to say a word. They don't have to present any evidence. And so you cannot, the only person you look to for evidence is the state. Because the state has the burden of proof, they go first. And you'll hear the entire state's case. At the end of the state's case, while Mr. Moore doesn't have to prove anything, he still has the right to present any additional witnesses for your consideration. So that's a very logical reason, again, aside from the fact that you need to go through all four parts, why you don't want to jump to a conclusion, because you've got to hear all the evidence before you can make a decision. So it's very important. That's just a common sense reason that you just can't let yourself make a decision until everything is done and all four parts are completed. Now, what will you be doing? We know you'll be assessing the credibility, and you and I both know it's as we've gone through life, there are situations where you watch somebody and what they're saying doesn't connect with their body language or some facial expression, gives you a concern, and you say, that's not, that generally is something I don't think that's credible or believable. If you have that feeling during this trial, make a mental note of that. Just don't jump to the conclusion that I don't believe that. And the reason I say that is this. When you get back to begin your deliberations, you can raise that issue and say, you know, it's been my experience in life. Maybe one of your fellow jurors can allay that concern, can say, well, you know, I think this is really a strong and overrides that and may satisfy you for that. So it's, again, just an example of why you don't want to leap to the end. Just make the note. And then when I say mental notes, they're typical, and y'all don't have to make this decision early on, but one of the things that I hear from time to time, and some judges, we all vary, some judges don't allow juries to take notes. I allow it if they want to, but I hasten to add to that is that situation that some people are better note takers than others, but if you happen to be looking down and you miss that facial expression, it would be, or that body language, it would be critical, then that note taking has been detrimental for you. So keep that in mind. And the second reason is this. Ms. Dahl is the court reporter, and she has, as I told you when we qualified, she has the responsibility of taking down verbatim what everybody is saying and what everybody says throughout this trial. At the end, when you begin your deliberations, if you have a disagreement about what a witness said or didn't say, we can replay that testimony for you so you can hear it again. That's another reason why it may not be necessary, but some people choose to do that. And if you want that, if you'll just let us know, we'll make that writing, we'll make the pad available to you, and I'll give you some further instruction concerning that. But most importantly, and I'll share this with you, a time when I thought, well, that makes some sense. I had a trial years ago, and the jury didn't take notes, but during the deliberations, they wanted to rehear some testimony. Then they asked for notepads because they were more focused on what that person said. They'd already made the observations and judged all other parts of it, but now they wanted to know specific words. And I thought that's a very effective way of using notepads, I think. Again, I'll leave that to your judgment. You can if you want, you don't have to. That's up to you. Now, after we hear the evidence, the attorneys, as I told you, will give a chance to talk with you about the case, discuss the evidence, and discuss inferences that you may draw. And they will help you work through this process that I'm sure is not something you do every day, but don't be concerned about that. Because while you don't call it deliberations, everything we do in life when we're making a decision is a deliberation, and that's exactly what you're going to do. And I'm privileged to try this case with you. At the end of this case, the last thing I'll give you the law. And I'll go through the various aspects of the law, and I will just discuss the elements with you, and then, of course, task you with decision-making of deciding what you find to be credible and believable, taking the law and applying it to those facts, and we'll look forward to hearing your decision at that time. Thank you for your attention to my remarks. I ask you to please give that same attention now to the attorneys as they give their opening statements. Solicitor.
Thank you.